Real, true education, not fake news. It's the 26th of October 2020. We're in the winter time. I don't agree with it. It's a nuisance, long nights. And it's about 11:30 the present time anyway, winter time. And this is on the North-South Interconnector and 13H. And the impact of case C2419 and the options. Now before I start, when you're given legal advice on this, there can be all kinds of implications, and I have to say that I can't be held accountable for its use. It's the best I know, it's the best I can give, and there are risks in all legal situations, and I can't assume those risks. In what I'm going to show now, it has been suggested to me that I challenge the North-South Interconnector on this new case, C2419, and having thought about that, I'm inclined to think it might not be the best way for me to proceed. There's a lot of other fish to fry, and an awful lot of groups have been very good to me all through the country, and I have blocked a good few wind farms, but I didn't manage to block my own. This judgment appears to mean, from my reading of it, that I can challenge under section 160 of the Planning and Development Act any wind farm, and I'll be looking at that now in due course, particularly the one beside me in Rara, and we'll give it a belt when the time comes, but that'll all take time. Also, I'm making every effort, and some groups are already planning to challenge wind farm consent on this new ruling, which vindicates what I've been saying. Now, I'm normally of a pleasant disposition, but on this issue I feel I was very badly treated by the local groups on the pylons, and they have to take responsibility for what the mess they've left. So we're going to look at it now, because I want to make it clear that anyone can look at this will know what I'm talking about. Suggestion is that there'd be a meeting maybe in Muff School or something, and people would come to it. But you can't do that now with the COVID for at least 4 weeks, maybe 5 weeks. And this is the best we can do. And I'm not so sure if many would come. And we're going to look at what the options are. And people can look at it or they don't. There are, in the County Meath, in the County Cavan and the County Monaghan, some terrific and great people. And one of those unfortunately died. He was Owen Brannigan in Monaghan. God, he was a great fella, and his passing suddenly was a great loss to me too, because we saw eye to eye to a certain amount. And up at the County Meath, there's a few great people up there, and they're so good. And then there's the rest of them. There's North East Pylon Pressure Group, who have shunned me, and indeed many of the Monaghan group have shunned me. They'd consider I'm some kind of an idiot. And I went to a meeting, a local man asked me would I go up to a meeting of North East Pylon Pressure Group in Navan. I think it was 2 years ago, this time of year in October. And I wasn't going to go because I knew I wasn't flavour of the month. And I've never been given the microphone there. I'm never allowed to speak at any of their meetings. And I went because he was driving, and decided I'd tip out and he'd leave me over at home and have a couple of whiskies while I'd be waiting, and sure, it'd be a bit of crack anyway. And I was paying no heed, I wasn't taking any part. And when I went up for my whiskey, when I came back from the bar, the head beetler, Pádraig Riley, come down and ordered me out. So one man stood up and asked why it was happening, but none of the rest of them did. And my own feeling on some of them people up there in Meath, and maybe to a lesser extent in Monaghan, they bloody deserve the pylons. If that's the way they want to behave, and if they think they're stupid politicians, Damien English and these other idiots and Thomas Byrne are going to get them put the pylons on the ground, they're not right in the head. Having said that, I've always liked to advise and put my brain to the use it's good at. It's good at this, it's not good at other things. And as I say again, those who use this advice, this is only a pointer on the way to go. If there was a challenge being taken on the North-South Interconnector now, I presume I wouldn't be doing it. And I'd say you'd need lawyers, and I know the lawyers to do it. There's only about one set of lawyers in the whole country that can do this. So we're going to take a look at it, and I'm going to try and explain this to you. And I know many people get very hard to understand how the law works, and to me it's just second nature. It's like water on a duck. It's just nature to me. I have no problem with it at all, but not everybody has it. One of the little things I see here is when I'm doing work on the interconnector, the way to spell it, interconnector, O-R. And I've been corrected. Would you believe people tell me I spell it wrong with an E-R? But a baler is an E-R, a binder is an E-R, a mixer is an E-R, and connected is an E-R. Well, why is connector O-R? Not a big issue. But would you believe it? Many people do check me on these things. So I'm just going to pause a second now. Now, in the case C24/19, which came out recently, what happened there was, again, and I've said this again, the local group challenged an application for a small wind farm in the Flanders area of Belgium, in the court in the local country of Belgium, and they sent it to the European Court of Justice, which is the guardian of the treaties on the functioning of the EU, and the Lisbon Treaty, and the treaties which grounds the EU. So the European Court of Justice, its job is to make sure those treaties are kept. Because if you don't have compliance with them, your whole concept of the EU breaks down. The law doesn't apply equally along the EU. And so in Belgium and in Ireland we have guidelines known as orders and circulars in Belgium. In Ireland, it's the National Renewable Energy Guidelines of 2006. The Irish guidelines are not relevant to this, but it's the same law, so it's the same decision, and it applies directly. You have no problem shooting down any part of a wind farm, and there's one here for a wind measuring mast, and hopefully the health will stick it, and I'll give them a run for their money on that when the time comes. But anyway, the issue was being made. Now just remember again, I have to talk to everyone so that the ordinary person can understand me. The guidelines for wind energy are relevant to the pylons. It's hard to believe that. They're the same thing and they're very relevant, but it's complex to explain it for the pylons, much more complex than for the wind farms. But don't turn off, I will try and explain it. What the Belgian government was saying and what the Irish government are saying is that these guidelines are only for the love of us people. They're so good. They're not compulsory. They don't have to make them. They did leave them out there and threw them out there and the planners can follow them. And so we love you all, you know, we're great fellas all together. Right? This order in Belgium and the circular and the guidelines in Ireland, they're not compulsory on the government to make. The government does not have to make them, they said. And we're only doing them for a bit of guidance and a bit of help. But of course, the planners in the various areas, like Cavan County Council or Meath County Council or Burpenola, haven't a clue about anything to do with wind, pylons, chemicals, nuclear power, fisheries or anything else. How could they know everything? And so these guidelines are used because they contain the setback distances. So you get the point that the national governments were opposed, and they're all the one in the EU, they all talk to each other, were opposing the case. They said these guidelines cannot be challenged and are not subject to an SEA, a Strategic Environmental Assessment, because they're only a kind of an idea. They have no formal thing, there's no law, there's no regulation. There's no regulation made under the law. They're not stamped by the Minister or anything else. They're made here by the Minister for Energy, all right. And national guidelines, this is what we recommend. 500 metres between the turbine and the house, irrespective of how big they are. Okay. So, I hope I'm getting that across. And so, they were saying it's not compulsory. It's not compulsory. But the court looked at it. And of course, the government didn't have to make them. But the courts will accept that the guidelines are the best practice for wind turbines. The courts in Ireland, that's it. But what the European Court of Justice ruled was, it doesn't matter a hoot whether they're compulsory or not, whether you ignore them or not. You can throw them in the bin, or you can do what you like with them, and I can think of a few phrases that would cover that, but I won't do it, say it here. It's whether there's the authority to issue them. Whether there is the authority to issue them. Now, do you get that point? The national governments were trying to get out of doing the SCA. They said it's not necessary. I don't need a strategic environmental assessment for all of this. When the actual directive itself, 200142 EC, you can get it there, says that a strategic environmental assessment has to be done for this industries, including energy, which sets the framework for the EIA, for the local project assessment. You understand that? The SEA sets the framework. It's the overarching thing. When Ireland brings in an energy plan, it has to put it through the SEA. When Belgium brought in the thing, it has to do the same. You can't come along and do out regulations and say they don't comply. They're not part of it. They are part of it because they're a regulation designed to bring in the national plan or programme, the public plan or programme at national level. And I was fighting to get this going, and I was hoping that the NEP crowd would bring it into the European Court, and they laughed at it. They wouldn't deal with it at all. I don't know if they even know what I was talking about. They wouldn't even listen anyway. But the point about it is that this is the situation. You can't make a regulation on a bit of paper that's meant to guide something which is a plan or programme, the implementation of it, if you have the authority. Now, if it was we'll say the Kells Weight Watchers Club, or the Kingscourt Stock Car Racing Club, or the Sacred Heart Sodality, or Legion of Mary, or Order of Malta, they have no authority to make it. They can make whatever regulations like that have no authority. It's the authority to make it. And the Belgian local government in Flanders had the authority. And the Irish government has the authority. And that's accepted by the courts. And in doing that, the European Court of Justice blew them out of the water. It blew them out of the water. And hit them where it hurts. And proved what I was saying was always right. Now, I mentioned Meath and I mentioned Monaghan, and I have to say here, I'd be a fool not to anyway, in the Cavan area there's great people, and they're great supportive. And when I took my judicial review, they went to all lengths to help me, and it was so good to do it, and so great. And we were so disappointed when Max Barrett ruled that because the pylons are a project of common interest, the Board Planolo has no substantive decision to make. In other words, the entire planning process was only a matter of form. All of that in the Newmore Hotel, the inspector and everything else. He ruled it was a matter of form. Didn't matter. They couldn't refuse it even if they wanted to. We had to come down the road and hold our heads down. And I got many's a slagging from Greens and lefties and other people about you wasted our time, wasting public money. I had to pay nothing, only just the fees, which was about €400. To stamp the documents, it wasn't that much. And a couple of dinners and a couple of mugs of tea. But that was what happened there. Now, as I said, challenging wind farm planning commission now is fun. We'll run the guts out of them. We have them where we want them. Their back is to the wall. And by God, as far as I'm concerned, when I get me opponent again the ropes, that's the time to give it to him. And the next thing is to try and force them to take down the wind farms. That'll be the next job. Now, the Derrybrine wind farm was granted a planning permission in 2004 in Galway. And there's a section 160 of the Planning and Development Act which allows any citizen to go in where there's no planning permission and ask the court to have it taken down and removed. Now, when you take a judicial review, you have 8 weeks. Must just check the time. You have 8 weeks to take that judicial review. 16 minutes. If you go in a day later, the courts will tell you get out. You have your chance, that's it. And that's only fair to the developer because he can't expect you to wait forever to take your judicial review. So you have 8 weeks. There's allowances made for Christmas and things like that. So, technically speaking, you can't go back in. And when you do try to go back in on the pylons, they'll oppose you. And the thing is that's the great pity not to go in within the time because you get rid of that messing. However, this judgment says that if they're in breach of EU law, out they have to come, and that includes the pylons. Now with this wind farm here, it's built, so they have to get the bulldozers in and dig it out. Will that happen? Well, they'll fight us on it. They'll fight us. Will I be around? Will I live long enough? I don't know. Definitely I'll enjoy the struggle with them. But someone else may do it. Once we get one pulled down, we'll pull the rest of them down. But the thing is with the pylons, they're not built yet. So you could get into the court and get your injunction against it. Section 160 allows you to apply for an injunction. If it's under 3 million, the land, it's the Circuit Court. If it's over 3 million, it'll be the High Court. I presume because there's a long area of land here in the state, it'll be the High Court, and it'd be nearly better if it was the High Court. Because there isn't, strictly speaking, an appeal from the Circuit Court. It's more or less meant for our walls and drains and things. It's not meant for a big thing like this. But the section is there, you're entitled to challenge on that. So, I keep thinking to myself, what am I forgetting here? Am I leaving everything else? Well, we can do another video anyway, and this is the way it'll be done. Now, I want to emphasise too to people, if you're watching this and you're not interested, turn it off. This is for a small target audience, right? This is to supplement not being able to go into a building and talk to a group of people. So we have the situation where I'm not liked by NEP, and I'm not liked by Monaghan, and I'm all right in my own community, and I don't give two hoots who likes me or doesn't. The only thing about it is, if you're persuading people, you as well have them on your side, and I have failed to persuade them, and the pylons are coming. The pylons are coming. I hear nothing about the Northern group taking a challenge. It's wide open up there, because the law is very strong in Britain. In fact, there's a case out of Britain where an SCA was done to build a town, and they decided not to go ahead, and they forced through the European Court to undo the SCA with another SCA. Very strict. It's very strict. So that's basically that. In that environment, what do? I will be in the courts myself, probably fighting the local ones. Why should I bother? The pylons are a mile away from me. But I'm very, very sorry for decent people up there. I was completely shunned, and that's the way. But I've been proven right. Now, one very important thing in this, I hear word of people still arguing about the right to enter land. They're getting solicitor advice about going in on land and airgrid. The situation is settled. In 2007 case 151 judicial review in sections 9 to 47. Airgrid has the right to enter land, and you're wasting your money trying to get a solicitor to advise you. They have the right to enter land under the Acts for laying electricity and section 182 of the Planning and Development Act. They have the right to do it. But they have to be, like Airgrid, a public body. And this has come up to great effect, and I have already stopped a wind farm because they can't lay the cables under the ground because the land is owned by the farmer alongside the road. We're blocking them on that. And that's Max Barrett's judgment. You have to have some consent from the landowner to get planning permission. And if the farmers object, they cannot give you planning permission. And the Tahart wind farm here is blocked, and the Cool wind farm is blocked, and it's me that got them blocked. But the landowners did object, and that's a great help. And in some cases, in this one here, they didn't object. So what happened in the last time was, and I have to be remembered, there are maybe people in other parts of the world who haven't a clue what I'm talking about. I have to try and cover everybody, so to keep it interesting. It's 20 minutes. We'll go on another little bit. What happened in 2010, I think it was there was a previous planning application for the pylons as an ordinary planning thing. I think it may have been a strategic infrastructure development. It didn't matter. And it was all boasting about how the groups caught them out with the size of the turbines. Well, that's baloney, because under the Planning and Development Act you can put in an amendment. So that happened here in this one. There was 5 turbines originally. It was reduced to 7. Sorry, it was reduced to 5 because I made them do it, and they can do that. They did it in Tahar. They wanted to change the size of the turbines, and they did it as well. So the point I'm making to you is that's baloney. That some way NEP or somebody forced them or spotted the turbines were the wrong height. That's cod's wallop. There's no problem amending a plan or a project description. The reason it was taken down was much more sinister. It was to bring it back again and get it brought in under the PCI, a new directive which was brought out. Okay? And that's 347/2013. Now, just to explain to you, it's I'll soon end this. I'll just end this and come back again in a second. This is a map of the pylons, rough, and it starts here in Woodlands near Trim and County Meath. It travels into Cavan here, a distance of about maybe 40 kilometres, and it's only going through Cavan about 5 kilometres, about 3 miles. It goes into Monaghan about 14 kilometres, about 6 or 7 miles, and then it goes into Northern Ireland at the Red Mark, and it's been joined by a section of pylons from County Sligo, Shranana, some kind of a funny name, up to Turleenan. The place they meet in the north is Turleenan, so there's a link to it here planned, and that's for 600 megawatts of wind energy. Understand? So you can imagine Ireland is this shape like a teddy bear, and this starts here and it's going up and across the border, and then there's a piece from down to Sligo, which is a good distance, probably 50 miles, going to the northern tip of it to accommodate renewable energy. Now that's 22, and we're going to stop there now and just come back in a minute now with another section on this.